Okay, so hi everyone, and thank you for joining us for this month's Now What Legal Information series. Rick Peel from the Oregon Law Center is with us tonight, and I am going to let him finish introducing himself and tonight's topic.
Thanks so much, Amy. So yeah, I'm Rick Peel. I work at Oregon Law Center. I'm a supervising attorney, been there since 2020. I was practicing landlord-tenant law in Massachusetts before that. So middle of the pandemic move for me, which was interesting, but I'm here to talk about my specialty in the world of legal aid, which is landlord-tenant law. And so I'll talk a little bit about the Oregon Law Center just for a couple of minutes before we dive into that topic. So tonight's topic is going to be all about the eviction process. Oregon has one of the most unique and, from what I've learned, constantly changing landlord-tenant processes in the entire country. So it's a good thing to brush up on, and something that I need to make sure that I'm always updating myself on. Because even just in the last couple of weeks, there's been some changes. So anyway, without further ado, we can get started here. So I work at the Hillsborough Regional Office of Oregon Law Center. We are a statewide legal aid organization. The Hillsborough Regional Office is located here. It's in downtown Hillsborough, actually really close to the law library, almost kitty corner from the courthouse. So you can typically find us there. I should note, we say front desk 9 a.m. to 4 p.m. there. That's to call in. As of right now, we're doing afternoon office hours only of 1 p.m. to 4 p.m. So if you have any questions, come on in. That's our mission, is to provide justice for low-income communities in civil legal aid. We are not going to represent folks in criminal cases, but we do a lot of other stuff. These are the counties we serve. We can go over that quickly. And this is the kind of areas of law that you will find folks in our office that can help. So we're looking at housing, public benefits, employment law, civil rights, all manner of things that, folks can find in their everyday lives. We help with restraining orders. We help with evictions. We can help with wrongful terminations from employment, that sort of stuff. This is just a kind of brief introduction to the sorts of things we do. So in case anyone wants to contact our office, we can go all the way up to full representation. So let's talk about Oregon landlord-tenant law now. I always kind of start with this basic caveat. I cannot go into all of Oregon landlord-tenant law. There's just not enough time. I do not want you folks to have to sit here for hours and hours. I think sitting in front of a lawyer at 6 o'clock at night is boring enough, but to do it for hours is probably a little too much. That being said, we're going to talk about a lot of the main highlights. Chapter 90 is the statute and subsequent scheme where you're going to find Oregon landlord-tenant law. A lot of it is written in a way that tenants can interpret. That being said, I'll point to some resources for folks who are unrepresented at the end of the presentation. If you have any specific questions or feel like you cannot read the statutes to understand things, there's all manner of legal information out there for folks. So I want to cover the eviction process. And so in order to do that, we kind of need to talk about some of the basics of Oregon landlord-tenant law to kind of jump into that. So there's a few different types of tenancies. You'll hear these every so often. Week-to-week tenancies, just like it sounds. You're there for a week at a time. That being said, 10 days notice has to be given for a landlord to terminate a week-to-week tenancy, and same with a tenant. There are not really any protections for week-to-week tenancies, unlike the rest of Oregon. So Oregon has what we call just cause eviction protection. That's a fancy way of saying if you have been in an apartment for over a year, you have a number of protections. You cannot be given a no-cause eviction notice. There's a couple of very small exceptions to that. The general rule for folks to think about is if you're in an apartment that is not in the same exact building as your landlord, right? So you're not like sharing a room or renting a room from the landlord. If you've been there for over a year, then there needs to be cause to evict you. Cause meaning non-payment of rent, violating the lease, or we'll get into these later, but what we call the landlord qualifying reasons. Anyway, under these week-to-week tenancies, tenants have tenant duties that they have to comply with, and landlords have the same. You'll sometimes see, in my line of work, you'll see landlords and tenants try to make these little agreements like, hey, this isn't really a tenancy. You tenant are going to pay me a lot less than a normal tenant, but I'm not going to fix anything for you. It just doesn't work like that. That's not really how the law is designed. If you're paying for the consideration of staying in someone's house or apartment, you're a tenant. That can get a little sticky only in the context of like vacation rentals or hotels. Generally, if you've been in one of those for 90 days or more, though, you're considered a tenant. All right, so month-to-month tenancies. This is like the most common probably type of tenancy. It, again, is very literal. It means there's 30 days or 1 month per rental period. Typically, the rent's going to be paid at the beginning of each month. What makes it a month-to-month tenancy is that a tenant can terminate that tenancy by giving 30 days notice to the landlord, right? Giving 1 month's notice. Used to be back in the day that in Oregon, a landlord could give the 30 days notice at any time, and that would end the month-to-month tenancy. But with the passage of that just cause eviction statute that we talked about, landlords can give 30 days notice, but only in the first year of occupancy. After that, they've got to follow the just cause eviction protection. So we'll get to that again, like I said. I'll leave this up here for just a second, but there are landlord and tenant duties that are obviously really important that we will get to here in a second. So fixed terms, this is another really common type that you're going to see. That just means there's a written lease or a contract between the landlord and the tenant. So they're going to be the most rigid for tenants. There's also going to be the most risk of a tenant, theoretically breaking a term of the lease. Now, generally speaking, a tenant's not able to break this lease, right? So if it's a year-long lease, the tenant can't just say, well, I'm going to leave a month in. I feel like this isn't a good fit for me. There are a couple of ways that tenants can break the lease and not pay a penalty. The first would be in the case of fleeing domestic violence. That can be found at 90.453 of the Oregon statutes. It's a really complicated process. Essentially, as the tenant, you're going to have to provide a statement to the landlord of what happened, along with some kind of verification of the domestic violence situation. And the other thing is, if a landlord refuses to do their duties as a landlord, like refuses to fix something, there's a process for a tenant to break the lease that way. Landlords can only terminate their tenancies, these tenancies, for breaching the lease, or if there is at the end of the fixed term, right? So at the end of the year, as long as it has been 1 year or less, at the end of that term, a landlord can give 30 days notice to vacate. How that will play out, it sounded kind of complicated, but the easiest way to think about that, how it's usually going to play out, is a landlord and a tenant are going to sign a 1-year lease agreement. A landlord would smartly, let's say July 1st is the beginning of the tenancy, right? You sign the contract for July 1st, and then the ending date would be June 30th of 2024. So the very last day of the fixed term is short of 1 year. And then a landlord, anytime up until that year ends, can give a 30-day no-cause notice if it's not working out with the tenant. After that year is up, though, so in that hypothetical I just talked about, at July 1st of 2024, the landlord cannot give a no-cause notice any longer. The tenant is protected by the just cause protections in Oregon. So this is really important. I hope this is one thing that folks will take away from this presentation. I know there's going to be a lot of minutia, but this one's really important. Just because somebody gets a termination notice from the landlord, which is step one of any eviction process, it's not the same thing as being evicted. That is the beginning part of the whole process, right? I look at that as the, initial demand from, the party that wants to sue someone else, right? It's telling them, look, you are on notice now that I have a problem with you. So what I mean by that is a landlord can give a termination notice. That doesn't make it true, and that doesn't mean that the tenant has to leave because of it. Now, there's some weird legal things that have to be in the termination notice that make it look especially scary for tenants. So in any termination notice, a landlord has to specify a date when the tenancy is going to terminate. So how that looks is, tenant, John Doe, this is a notice to terminate your tenancy. The termination date is 30 days from today, which is, August 25th. And it says you have to vacate by then. What that means is if you do not vacate by then as a tenant, the landlord then can go to court and actually start an eviction court case against the tenant. So that's why it says there an eviction only occurs after a tenant refuses to comply with the termination notice, and then there's a court case, right? Now, this is the other really important thing. Sadly, especially in some of the rural parts of the state, this happens a lot. We call it unlawful ouster. I've also heard it called self-help eviction or illegal lockout. But it's the idea that a landlord who is acting as a landlord tells a tenant, sorry, you got to go, or worse, shows up and changes the locks on the tenant. I had a scenario once where I was representing a tenant trying to negotiate on their behalf, and a property owner was letting the tenant rent a fifth wheel trailer on their property. And the landlord owner of this fifth wheel decided that they wanted to get their property back because they wanted to sell it. So they tried to give an eviction notice. They didn't really know what they were doing. They didn't wait that time period. They just showed up with a truck that had a trailer hitch on it, filled up the tires that were flat on the fifth wheel trailer, and tried to hook the trailer up to the truck and tried to just drive it off as a way to self-help evict the tenant. As you might imagine, we got a lot of damages for the tenant in that. In other words, the landlord was clearly in the wrong, and they made a very generous settlement offer as a result of that case. But it's a serious problem. A landlord cannot force a tenant to leave unless a court has ordered it. That's the easiest and simplest way that I can say that. If you ever find yourself a victim of that, meaning that a landlord has removed you from your apartment or your home without process, I'd say, first of all, call our office, which we had the number back there, and we can put it up at the end of the presentation, but go right to the courthouse in your area. So the Washington County Circuit Court, go right to the civil court clerks, explain this is what happened. And you can likely file something yourself because it's not very hard to prove that this happened. Obviously, having a lawyer is always helpful. But the final thing I'd say about that is if a tenant is a victim of this kind of self-help eviction, which can not only include changing the locks, but can also be shutting off the utilities on a tenant in retribution to them, which we see that from time to time as well. The tenant can obtain injunctive relief from the landlord, which means a court orders, hey, landlord, you need to fix this. The tenant can terminate the rental agreement. And the tenant may collect damages of up to 2 months rent, or what we call actual damages. So if there's a lot of out of pocket, we can typically a tenant's attorney can get access for that. So I just want to address a question that quickly came up from Zane. Thanks for the question. With the new laws, why would a landlord ever rent to someone longer than a year? So it's a good question. I think the best argument I can say for that is in this business environment that we're in, like landlords are in the business typically and hopefully of trying to get good tenants that pay the rent. So if you get a good one, typically in my experience, landlords are going to try to keep them. I mean, that's kind of the simplest way I can say it, because every time there's tenant screening for a new tenant, you're kind of, I think I could say for a landlord, every time is a bit of a gamble. Just like as a tenant, every time you try to find a new place to live, it could be a gamble. You might think the place is great, but then until you actually move in and live there, it might not be so great. You don't really know until you try it. So that would be what I would say. Thanks, Zane, for the question. Okay, so there's a very pretty similar eviction process that every case will have. And so let's talk about that quickly. The first thing is that termination notice that we just talked about. So a landlord's going to give the notice of termination. The second thing, the tenant's going to stay beyond that termination period. The third thing is the landlord is then going to file an eviction case. We call that an FED, a forcible entry and detainer. It is a weird name. I don't know why it's called that, but some states we call it that. In Massachusetts, we call it summary process. Anyway, the point is, it is what we call eviction cases, FED cases. So the tenant is going to be served a summons and complaint by the landlord. So 5 is where we get to the actual court process, right? There's on the summons and complaint that the tenant gets, there's going to be a court date on there. That's called a first appearance date. That is not a trial. That is the first chance for the tenant to show up to sort of answer the landlord's allegations. So what we see if you go to eviction court, which in Washington counties are Monday mornings and Friday mornings, you're going to see, anywhere from 5 to sometimes 30 cases. Most of them are at the first appearance stage. It is the first court appearance. What is oftentimes going to happen at that first stage is the case is going to resolve there. And it's going to resolve, first of all, because sometimes tenants don't show up and sometimes landlords don't show up. So when one of the parties doesn't appear, the other party can win the case by default. The second way, and this is probably the most common thing you're going to see for resolution to these cases, is that the parties are going to make an agreement. Okay, so what we see really often is landlords and tenants are going to make an agreement where the tenant's going to leave in a certain period of time, right? The tenant's going to surrender possession, and in exchange for agreeing to do that, the landlord is agreeing to give them a little bit of extra time. You'll see things like, tenants allowed to stay for an extra month. The point of that is it is an agreement, right? Which means the parties have got to agree to it. That's the way that these cases can end at the first appearance date. If no agreement is reached and both parties show up to that court appearance, the next step is the judge is going to put an eviction trial date down. If the landlord wins a trial, then the sheriff would enforce the eviction. So we can get into that in a little bit more detail here. Termination notices. So this is something that I talk to folks a lot about. Termination notices are something that must be done very technically correct in order for a landlord to win, and they've got to have specific things. So you can see the 4 things that are there. Must specify a vacate date that is legally correct, right? Sufficient. It must be in writing, served and delivered in accordance with the law. The last thing is it sometimes has to have required language, which I put the veterans notice. There's a law in Oregon that it doesn't matter if you're a veteran or not. Every termination notice has to include the language found at 90.391, which is this particular language about veterans and who they can contact. So now we're going to get into the type of notices next. 90.396 are your 24-hour notices. So that is a really rare, not very often used form of termination that landlords can give. We call them the extreme and outrageous cases. So I heard about one once where the tenant was alleged to be juggling swords that he lit on fire, which was like grave, danger to the property that the landlord owned, which, I could see that maybe being extreme and outrageous, right? But it also talks about serious criminal conduct, threatening to harm someone who lives on the property, actually harming someone who lives on the property, manufacturing controlled substances, etc. I put there no right to cure. That means quite simply, some notices you can cure them as the tenant and avoid getting evicted. This is not one of those kinds of cases. So 90.392 is another thing you'll see a lot. They are for cause violations, meaning that as a tenant, some part of the landlord tenant agreement hasn't been complied with. So a material violation of the rental agreement, failure to comply with the tenant duties, or the non-payment of rent. In these cases, if it is possible to cure, the landlord must provide a date to cure and one way to cure. So there was recent case law about this. Generally, most of these 30-day notices, you're going to see actual cure language written in them. And that actually does say, in order to cure, tenant must do the following. Great example of this is like tenant, causes damage to the property. Let's say they leave a sink running and it overflows and damages something, right? So landlord can say, you've violated the rental agreement by causing damage to the premises. You have to leave in 30 days, which is the state, but we are giving you the right to cure. Now, the law says it has to be 14 days to cure. And then the termination notice would actually say in it, in order to cure, you must pay the amount it costs to fix the damage that you caused to the premises. It's a great way to look at it. So let's get to the tenant duties. We've talked about those a few times. They're pretty standard and straightforward. Tenants shouldn't damage the premises, should keep it clean. If they are the reason that vermin or rodents get into the premises, then it's the tenant's obligation to fix that. That's something we see litigated occasionally. If the tenant, for instance, brings bed bugs onto the property, then the landlord is allowed to make them pay for it. If the tenant did not cause the infestation, then the landlord's not allowed to. As you might imagine, that is really hard to prove and can be really difficult in court for either party. So those are your tenant duties. Termination notices. I want to talk about non-payment of rent because that's the most common type of eviction notice you're going to see. The law used to be that landlords only had to give a 72-hour notice for termination. As of this year, that was changed to 10 days. So there has to be at least 10 days of notice, other than in week-to-week tenancies on these non-payment of rent notices. They also have to give a cure date and a cure amount. So exactly how much is needed to cure to avoid the landlord filing the eviction case, and a date by which to do so. The other part about this is this most recent piece of legislation that we're referencing here created a defense for tenants, among other things, that if the landlord refuses to accept money that would cure, right? Let's say the cure date in this notice is July 29th. On July 30th, the tenant shows up with every dime owed. The landlord says, sorry, I gave you a cure date of yesterday. You didn't comply. Tough for you. The tenant has a defense. They can say, here you go. Here's my money order. That's for the exact amount owed. And landlord wouldn't take it. that can be a defense now. We call that a right of redemption. You don't need to know that, but the point is, up until a judge formally awards the landlord possession of the property at the end of the eviction case, the tenant can pay all the money owed and avoid the eviction. So 90.427 is the landlord qualifying reasons that we talked about earlier. We see a lot of litigation for this, and it's very sticky, but there are a couple common ones. The landlord wants to sell the unit, and there is a purchase and sale agreement that's been signed. The landlord wants to demolish or significantly rehab the unit, and it's going to be uninhabitable. So that's why the tenant has to leave. The landlord wants to move in, or they want a family member to move in. And then there's one like a unit conversion. So like, let's say the landlord's like, oh, I don't want this to be a rental for people anymore. I want it to be a pet shop or whatever, changing it to non-residential use. Couple things to know about that. Number one, there's 90 days required on those types of notices. The other thing is, as state law requires, if the landlord owns 5 or more rental units, then they must pay the tenant 1 month's rent as relocation fee when they give that notice. So it has to be received at the time. That's what the statute says. A lot of times you'll see that landlords don't quite own that number of properties. The only other thing I want to point out to you on that issue is localities. So like counties and cities are free to make their own rules about landlord tenant law. So in Portland, for instance, they have a whole different relocation payment scheme than the Oregon law. So 90.427 that I'm talking about here, is state law. It may differ by where you live within the state. And I just don't want to go into too much details there. So let's talk about eviction. We all know there are consequences to eviction for a tenant and also for a landlord, right? This FED case, forcible entry and detainer that we talked about, they can file, they must serve. The summons that we talked about that the landlord is going to serve has really important details on it, which includes when the first appearance date is. We've talked about the trial piece, so we can move on from that. Here's a great example of what the summons is going to look like. As you can see here, it has a case number on it. It has a plaintiff and a defendant on it. It also very specifically says that on May 30th, 2023 at 8:30, you must come to the courthouse. And then it gives some other really important information here. The landlord will win automatically if you don't show up. It talks about where you can contact folks who work for my organization for help through the Eviction Defense Project. And then it talks about how to get your trial. I want to point out here, if you show up on your first appearance date and you want your trial, that's great. You tell the court will schedule something, but they will require you to both file an answer that day, which you serve on the other side, meaning that your landlord or the landlord's attorney, and you have to pay a filing fee of $88. If you cannot afford $88, you can go to the court clerk's office and they can you can fill out what's called a fee waiver affidavit and ask that your fees be waived because you can't afford them, and then it would be up to the judge to make that decision. So post first appearance, I just talked about this stuff. About 2 weeks later is when we're seeing trials. The new law gave us a little bit more clarity, but a lot of time it's just depending on how busy the dockets are and when they have judge availability. But generally, I tell folks about 2 weeks after their first appearance is when they're going to have the scheduled trial date. Here's what the answer form that I was talking about earlier looks like. This is the one you get from the court. You show up at any court clerk's office, they're going to have this, but you can also get it online. As you can see, it's fairly straightforward for folks to fill out. It has a number of pre-written out defenses here, as you can see, and you just check the boxes. You can also list any other defenses. Generally speaking, drafting your own answer can be challenging. I would suggest that you talk to an attorney, because what you think is a really serious wrong that the landlord has done to you, it may not be a defense to the eviction. And there are some things that are absolutely the basis for a landlord to owe you damages, but they may not be enough for you to keep your house. So like if you have really terrible living conditions, like it is not habitable in your apartment, but you didn't notify the landlord properly, like as the law requires, it may not be a basis for defending against an eviction if you owe the landlord money. So that is a really important consideration. It's always worth it to contact an attorney to see if there is somebody that might help. I would like to point out for folks on this call, we just got some great news. The Oregon State Bar runs a lawyer referral service. That's a really great resource for folks. It allows you, if you qualify, to get a $35 an hour or $35 half-hour consultation with an attorney. And then typically you would then, if you wanted that landlord to represent you, you would make that attorney to represent you, you would make your own agreement for how they would get paid. But now they just got some funding to allow for folks who are income eligible. If you call the lawyer referral line, they may be able to get you a lawyer that's going to work for a cheaper rate depending on what you can afford. So that could be like $50 an hour, which I know is still a lot of money, but if it's going to keep your house for you, and the number of hours for the attorney's not that much, it's probably going to end up being worth it. So the lawyer referral service of the Oregon State Bar is a great resource for you along those lines. All right. So here are my tips for filling out an answer. You kind of have to raise the defenses that you want to rely on. The most recent House bill from this year that I talked about earlier does say that if, as an unrepresented person, you didn't know what your defense was, but you later want to raise it, you're not prevented from doing so anymore. The landlord may be able to get a continuance based on that, though. So the pre-filled out information is meant to be helpful, but it may not perfectly match your situation. I tell folks to be generic in your language as opposed to really hyper specific. I know that's like really kind of squishy, but the point is you want to inform the court that I have this kind of defense, right? I think the notice was defective, and that's probably going to be considered sufficient by a court. You don't have to say on this line of the notice, it is defective because it uses this language and that is wrong because of this, and this. Like the more specific you are, the more it can come back to kind of bite you. But ultimately, like, I get it. If you have a lawyer, you're going to always have better luck more often than not. And that's why, like, getting legal assistance to help, if you can, is really important. And that's one of the reasons why I do the work I do, is there's just a justice gap, and not everyone has access to attorneys when they really need them right now. So there are 3 different ways to defend at trial. I'll kind of try to go a little bit quickly here. There's notice defenses, factual defenses, and affirmative defenses. Notice defenses mean the notice is wrong. The notice is defective. The landlord didn't do what they need to do. They didn't accurately state the amount of money that must be paid to cure, or they didn't specify exactly what they're alleging that the tenant did enough, or there's required information missing. What this means is a landlord is going to have a tough time winning a case like this because they can't later amend the notice. So if a tenant points it out and a judge agrees, the case is going to be dead pretty quick. There are your factual defenses. That's like, nuh-uh, or as my old debate coach used to say, it's not true or it's not important. That's where you put out there, like, I didn't do what the landlord said I did, or it was actually the landlord having a defective, sink faucet. That's the reason why the leak happened. It wasn't my fault, right? Like, that's the kind of thing that a factual defense is going to talk about. I just tell everyone this: if you're in a landlord-tenant court and you're a tenant, you probably need someone else to testify on your behalf, because landlords unfairly, in my opinion, get a little bit of deference in eviction court, and their word tends to go a little further. And I don't really know why that is, but that has been my experience, and it is not unique to Oregon. I've seen that in everywhere that I've looked at landlord-tenant law, that landlord tends to get a little bit of the benefit of the doubt. So supporting evidence, documentation is going to go a long way in these kind of cases. So reduced rental value is one type of factual defense, and you can use it in a non-payment of rent case. You got to make your requests for repairing things in writing. Reduced rental value simply means that because the landlord didn't fix things, your apartment was not worth what you were paying for it. So if the apartment was in really, really bad shape, like let's say the roof wasn't working, so every time it rained in Oregon, your floor flooded and all your belongings just got soaking wet. You tell the landlord, you tell them in writing even, hey, you have got to fix this. This is not good. Well, you probably have reduced rental value claims. So if you have a non-payment of rent case where the landlord says, hey, you owe me $4,000 in rent, you could raise this as a defense, like, hey, I have reduced rental value because of all of this damage to my property because of the landlord not keeping it up, and here's my proof, here's my written notice that I gave to the landlord. Photographic evidence is always going to go a long way in these cases. Trying to describe something, believe me, does not ever get you very far. You got to have pictures, and sadly, with the way pictures are, sometimes they don't tell the true story that the tenant wants them to, which is why it's important to document things as best you can and take as many pictures as you think will help tell your story for you. Cure, we've talked about that. That's like what you can do to stop the eviction from getting filed. If the landlord files anyway, then cure may be a defense for you. Like you are saying, hey, I cured. They told me I had to pay $800 to fix the leaky faucet situation. That was my fault. I paid that, and now they're trying to evict me. I pointed out this case, KKMH Properties versus Shire, because sometimes the violation is of a kind that actually cannot be cured. And that's why the law is written in a kind of weird way. If the tenant can cure the violation, sometimes they can't. That was a case that found that the tenant could not possibly cure the violation, so it was not a problem that the landlord didn't give them an opportunity to cure. So we talked about the tenant denying wrongdoing. One thing I do want to say, there actually is talk about material violations in the statute. You have materially violated a term of the lease. That's what the landlord would have to prove. We don't have any case law in Oregon about what that means, material violation versus a non-material violation. So I can't really give you a good sense of how a court would interpret that. I look at it like, what's a good example? If you have a lease provision that says no pets over 50 pounds, and then you, at the time you move in, your pet that the landlord agrees is 45 pounds, but then your pet balloons to 60 pounds, while you're living there. I think you'd have a really doggone good case that that is not a material violation of your rental agreement. It's a very minor violation, right? But you can find those occasionally. So affirmative defenses, these are a little different. The tenant actually has to prove these things if they assert them. The first is retaliation. The second being waiver, the third discrimination. So let's talk about all those real quick. Retaliation is the idea that the landlord is punishing the tenant, right? Is retaliating against them because the tenant took an action that they are protected in doing, like requesting repairs or tried to organize the tenants into a tenants union or something. There's pretty bad case law, unfortunately, in Oregon that says the tenant has to prove that their protected action, like the requesting repairs or the tenant organizing, was the but-for cause of the landlord's decision to terminate, which, as you might imagine, it'd be really easy for a landlord to say, well, no, that wasn't the reason why I did that. And it's a hard affirmative defense to prove sometimes for that. It's not available to if a tenant owes rent to the landlord, and that makes things really challenging. In other words, if you owe a bunch of money to the landlord, then you take one of your protected actions, then the landlord files a non-payment case, you're not going to have an offense. So waiver is the idea that the landlord knew full well that you were violating the rental agreement and they didn't do anything about it until a lot later. And the idea in the court is it's not really fair. Landlord knew you were doing it. Clearly they didn't have a problem with it. Generally, the idea is the landlord accepts 3 months rent or accepts rent after having knowledge of whatever the violation is. They do it for 3 rental periods. They accept rent from the tenant anyway. You're going to be more likely to succeed if there's an on-site property manager. And I put that in there because if your landlord isn't on site, as you can imagine, the first thing they might do, let's say it's about a pool, right? You put one of those inflatable pools in the backyard and it says absolutely no pool. Well, if your landlord property manager is on site and there every day, then I think you're going to have a pretty good argument that they knew that that thing was there for 3 months before they did anything. If the landlord isn't around and doesn't come to check on it from time to time, you might have a harder time proving that the landlord knew. We put in here that it's particularly complicated. The statute is one of the most poorly one of the hardest to understand statutes I think I've ever read. Get an attorney consult. I think that's going to go a long way for you. So discrimination, the idea that because of a protected status of a tenant, that the landlord is trying to evict for that. I put here domestic violence discrimination as a great example. If there is pretty well documented federal law and an Oregon law that if a tenant is a victim of domestic violence and the abuser's actions are the basis for the termination notice, right? Like the abuser breaks a bunch of things during a really scary argument, that's going to be you're gonna have a really strong domestic violence protection as a tenant in that circumstance. The landlord's gonna have a hard time evicting you for that. And if they do, you probably have a domestic violence discrimination argument. There's your classic sort of protected class discrimination, race, sex, national origin. What you might imagine is landlords who are going to engage in that practice are typically smart enough to not put that in writing. Well, I don't know about smart enough, but they're maybe not going to put that in writing, so it can be difficult. Corroborating testimony and evidence is going to really probably need to be there. I want to flag this reasonable accommodation issue. If a tenant has a disability, sometimes that can negate an eviction notice, right? If the tenant was late paying their rent, and the reason they were late paying their rent is because they get a disability check from the government, and it is late because the government pays when the government pays, that's probably a reasonable accommodation issue, and there's probably a disability discrimination defense in a case like that. So settlement, the way settlement works is it ends up being what's called a stipulated agreement. If you end up settling at your first appearance or any time up until the court enters judgment, That's what it will look like typically, a stipulated agreement. What I tell anyone, if you're thinking about settling an eviction case, the word strict is the thing I want you to think about, because you have got to comply to the letter with whatever is in that agreement. Otherwise, the landlord's going to have a pretty easy time going back to the court and evicting you for failing to comply with it. So whatever is on that stipulated agreement, you better make absolutely certain that you can do it and abide by it. Otherwise, you might reconsider signing it. The way the law works in Oregon, this extremely strict probation that I talked about in a stipulated agreement can last for up to 6 months. And at any time during that, the landlord can allege that there is a problem or a failure to comply by filing a declaration of noncompliance. That gets served on the tenant. The tenant then has the burden of going to the court and actually asking for a hearing. If the tenant doesn't do anything after receiving one of those, then the eviction process starts. That's what I just talked about, so we'll move on from that. So I'll just go over this part really quickly here. The notice of restitution is what comes when either the tenant has lost at eviction trial, or they have failed to comply with their stipulated agreement and the landlord has informed the court. The notice of restitution then gets served on the tenant. It's going to give at least 4 days for the tenant to move out of that apartment before a sheriff comes to physically remove the tenant. It has to be served exactly as required in ORS 105.158 by a sheriff or a process server to make absolutely certain that the tenant gets it, right? This is your essentially last chance to move out on your own, or you may get an eviction, like the sheriff will come and physically remove you, and you will have that mark on your rental history for a number of years to follow. So I do point this out. FED cases are about possession. So what happens sometimes, if a tenant goes to the first appearance, says, hey, I want a trial, then rethinks that, or something else comes along, right? A new apartment they can move into. If the tenant vacates possession before a judge enters a judgment against them and gives the landlord the possession of the apartment back, then the judge in the case has to dismiss the eviction action, because possession is the only thing that the FED case is about. So once the tenant has given the apartment back, possession is no longer at issue, right? The tenant has said, I give up, you can have your apartment. Then that means the eviction case is over. I tell tenants, if this is the strategy that you're going to take, which sometimes has to happen, then they should absolutely, as soon as they can, give back possession of the apartment by moving all of their belongings out, getting the keys back to the landlord. If you have to drop them off, take pictures of where you dropped them off. I would still show up to that court date though, and I would tell the judge, I moved out. Here's my proof that I moved out. The judge should have dismissed the case as a result. All right, so Oregon Law Help and Oregon Renters' Rights are great places if you can't get an attorney to assist you with getting information about landlord-tenant law, and they put it into language that's easy to understand and hopefully helpful for you. The last thing I put here is Disability Rights Oregon. It's helpful guides to specifically folks who have disabilities. If you need help with a reasonable accommodation or a modification, right? Like you need a ramp to get into your apartment that has stairs, you're going to find guides there that can help. If you need a live-in aid, say to live with you because of a health condition, they have all kinds of helpful guides there. All right, so I just want to shout out that and Amy, go ahead, and if this is incorrect for any reason, here are the next couple of topics that we have for Now What presentations. I will stick around and do questions if folks have some. I would love to field questions. I just want to caution folks, I'm not going to give legal advice. So if you have specific questions like about the actual facts of a case, I'd say please don't ask those questions, because I really shouldn't give legal advice without doing the things I'm supposed to do. And if folks need me to or want me to, I can put our contact information back up. But thank you all so much. Please, if you have questions, you can type them in, or you can let us know. Is that the only way they can do questions, Amy, is through the Q&A thing?
Yeah, we have the Q&A, or you can raise your hand and we can unmute you.
Perfect.
I will stop the record in just a moment, but I just want to say thank you, Rick, for all of this valuable information, and thank you to everyone else for joining us tonight. Like Rick shows on his screen, we have the next series in our program about divorce on September 20th. So I am going to stop the record. And if you have questions, feel free to raise your hand or type it in the box.